Okay. Good evening, everyone. Thank you all for joining us this evening. My name is Jessie Jim.
Good evening. My name is Sharon Sandman, and I am the Assistant Field Coordinator for NAPS. And I'd like to introduce Jim Wabindato from Little River Band, Ottawa. Joined Indian Land Tenure Foundation in early 2014 as landowner. Education and program development. Prior to joining the organization, Wabindato was a realtor in Arizona and Wisconsin, a site manager with the Indian Land Consolidation Office, a realty specialist and grant writer with the Bad River Band of Chippewa, as well as an economic development director and casino board member for Little River. Wabindato holds a Bachelor's of Arts degree from the University of Michigan, where he was active in the Native American Student Association. Welcome, Mr. Wabindato, and I will give the floor to you now.
Thank you so much for this invitation. I appreciate it. As was already mentioned, my name is Jim Wabindato, and I have been with the Indian Land Tenure Foundation since 2014. The Indian Land Tenure Foundation is a nonprofit based in the Twin Cities of Minnesota. We are located just north of St. Paul. We have been in existence since 2002, providing services, information, and getting funding into tribal communities to address land-based issues. I myself came through the Little River Band, where I'm a tribal citizen. I had worked for the Bad River Band of Chippewa in northern Wisconsin, and have enjoyed my time here working for the Indian Land Tenure Foundation. The mission for the Indian Land Tenure Foundation is to help restore to ownership, Indian ownership, all lands within the original treaty reservation boundaries. And jokingly, what I will often say is that I know that that will provide job security for me through the end of my career, as it took well over 150 years to get to this situation. And I suspect that it'll take quite a while to return that. Today I'm tasked with talking to you about wills and what they can do for you as a farmer and rancher, the urgent need to have those in place to deal with your trust assets, but also your business assets and some of the other things that help you be successful in your daily life. Today I'm going to be talking a little bit about the American Indian Probate Reform Act and why wills are critical to trust asset management. I also, at the request of, I'll start with, a will is a legal document that allows you to determine what's going to happen to your stuff when you pass away. As you can see, one of the important pieces of a will is that it's not final. So if your circumstances change, if you change your mind, you can change it as often as your resources allow, depending on how complex and how much you would like to engage the services of an attorney. It may limit how often you'll come back, but it is your legal right to make changes to your will as often as you like. One of the key pieces to working with the Department of Interior, the Bureau of Indian Affairs, and your trust land, especially as if you should be an allotment owner, is the American Indian Probate Reform Act. It was passed in 2004 and applies to all probates for people who have passed away since June 20th of 2006. One of the things that we point out is that it does strongly encourage you as an individual to write a will, because if you don't, you're leaving the future of your Indian land, perhaps even your Indian monies, to a federal judge. And it is spelled out very clearly in the law what will happen. So if you don't put together a will, you're kind of giving up some of your ownership and the ability to decide who, again, is going to get your stuff. There are a few key terms that we like to cover when we're discussing the American Indian Probate Reform Act, specifically heir, eligible heir with a will, and eligible heir without a will. An heir is simply a person who receives your property when you die with a will, or without a will specifically. When you do not have a will in place, it's going to limit who is actually eligible to inherit your trust assets. We're primarily talking about Indian people, perhaps co-owners. There is also the possibility, if your children have passed away, that your grandchildren might be able to inherit it. But with a will, it does open quite a few more doors, specifically any of your lineal descendants, whether they're enrolled with an Indian tribe or your own tribe, that they will be able to inherit your stuff. To die without a will, the legal term is called intestate. So if you should come across the term intestate, that means that somebody did not write a will. If you write a will, as you can see on here, they kind of change it. We still say eligible heir, and if you were to say heir to an attorney or to a judge, they'll know what you're talking about. But as attorneys, they often use legal terms. In this case, it is going to be a devisee. You're giving them something, so they are devising your stuff. Another key set of terms are to understand what are trust assets. The federal government will only probate trust assets, and those are going to be trust and restricted fee lands that you own as an individual, whether they be in whole or in fractional ownership with your family, relatives, as well as others that may have been married to somebody that you knew. Individual Indian money accounts are also considered trust assets. In our conversation today, as operators, farmers, ranchers perhaps, there are two key things. Permanent structures on trust land are not considered trust assets. If you were to operate anywhere else in the state of New Mexico or perhaps Arizona off of an Indian reservation, the house, barns, all that stuff goes with the land. But because of a law that originated from a lawsuit in the state of New Mexico, federal government passed some changes and changed the law specific to Indian country and to Indian lands, so that permanent structures like the schools that were built in the 40s and 50s, the barn that you may, or hogan that you may have constructed to help as part of your grazing activities, those are not considered trust assets and will not be handled by the federal government. Grazing permits are the ability for you to use tribal land, Navajo Nation land, for purposes of economic use. Grazing permits would not be considered trust assets either. And then finally, any other personal property or items that you may own would not be trust assets. So the reason that we cover what assets are important is because what happens when you pass on. Trust lands or trust funds will be probated in federal court. Tribal, cultural, or other assets are going to be probated in the Navajo Nation court. In other Indian tribes, it might be a third jurisdiction. You might have some of your assets probated under state law, but because of what the nation has passed, your leadership has set up a system that bypasses the states of Arizona or New Mexico. They do take into consideration some of the aspects of what occurs under each state law. So depending on which part of your community, which area within Dineta that you live, there may be some aspects under Navajo law that are adjusted accordingly. If the tribe where your lands are located does not have an approved APRA probate code, APRA will apply to those trust lands. Navajo is not one of those federal probate codes for trust assets. So if you pass without a will, again, dying intestate, the American Indian Probate Reform Act will just set up a structure for an administrative law judge to determine who will receive your assets. Similarly, if you do not write a will, the Navajo rules on probate procedure, Rule 6 will determine who receives everything else that is not a trust asset. So again, a valid will allows you to choose who gets your stuff. There are nuances under each law that strongly suggest that you get legal advice depending on where you're located and who may have funds. There are organizations, including on occasion the Indian Land Tenure Foundation, who can get you access to will services. I know it's an uncomfortable conversation to have about death, and culturally speaking, it's not something that many of us are supposed to do. But unfortunately, as time has gone by and the federal government has stepped in and become a trustor over our stuff, including a lot of the land, it is important for us to have to work through their court system to protect what we've worked for or have received from our ancestors and pass them to our kids. So again, we strongly recommend that you get legal advice and that you put together a will. I did mention that there are places within the Indian country that have their own federally recognized probate code. Again, this is for individual Indian trust assets. So for those of us in New Mexico who may have shares in allotted Indian lands, the American Indian Probate Reform Act is important. Here you can see, beginning in shortly after the Indian Reorganization Act in 1936, the first probate act was passed by Congress for the Klamath Reservation, the tribes in Oklahoma and in the Pacific Northwest were set up through into the early 80s to have separate codes, and then into parts of the Lakota country. In the passage of the American Indian Probate Reform Act in 2004, they did set up a secondary pathway that does not go through Congress, in which tribal leadership can put in place a tribal probate code, and that probate code has to be consistent with the features of the American Indian Probate Reform Act, but it can deviate from APRA to reflect the culture and the moral values that your community has. If the tribal leadership should put that in place, it goes through a federal process, and once recognized, all judges will adjudicate trust assets according to those laws rather than this uniform federal law. I'm going to cover, again, the American Indian Probate Reform Act because it does affect trust assets on the Navajo Nation. There are two aspects because of the efforts to reduce fractional ownership. There are roughly around 175 tribal communities that have had allotments, including Navajo, and as such, fractional ownership has occurred through time, beginning with treaties in the 1840s and 1850s that allotted to individuals, and going up until the Indian Reorganization Act in 1934, that land would go to individuals and could not be alienated. It could not be technically taken outside of the tribal realm. And as such, instead of getting passed on to individuals, it was split amongst the heirs. In 2004, they passed APRA to change that. They began the process in 1983 with very little success and doing some things that didn't work very well to protect the rights of the landowners. So going back to APRA without a will, meaning somebody did not make the effort to have a will put in place prior to their passing, to protect against additional fractional ownership, they created two buckets or two baskets for the law to follow. That which is 5% or greater and that which is under 5%. And depending on where you're at, most people are going to be less than 5%. A number of things happen when you do not write a will. Again, without a will, eligible is going to be restricted to members of federally recognized Indian tribes, those who might be eligible, and lineal descendants within 2 degrees of the Indian. So your children or your grandchildren of an Indian person would be able to, according to the federal government, inherit your Indian land and keep its Indian status. There are additional pieces in here, but you can review those at your own pace should you get a chance to review this presentation later. Without a will, if you have greater than 5%, your surviving spouse will only receive a life estate, and for your eligible children, they will split it equally. So if you had 10%, again, your spouse will get no permanent ownership of that land, and this is trust land or restricted fee land, but your kids would split that 10% equally amongst themselves. So 4 kids, they would each get 2.5%, 2 kids would each get 5%, and you can continue to do the math depending on the size of your own family. Again, if you've got 5% or greater, the law actually spells in excruciating detail who is eligible. And ultimately, if you do not have any heirs, it is distinctly possible that the Navajo Nation would get your ownership interest in an allotment, and that would reduce the fractional ownership. Again, the role that the federal government put in place for itself. There's a picture that gives you several different examples. Again, I won't go into great detail, but you can kind of see that depending on how it shapes up, down in the bottom right-hand corner, that it might go to the tribe, or somehow if it were in a public domain allotment, it's possible that the federal government would sell that and perhaps sell it to co-owners, but that it would allow those interests to be sold by the United States. The key thing, again, because many Indians own trust land fractionally at less than 5%, it's important to understand that there is the single heir rule. And explicitly what will happen is that your eldest child is going to get ownership of all of those small fractional ownership interests. For instance, I was doing a presentation like this in a tribal community, and a woman came up to me afterward to ask a few questions. And during the conversation, I picked up on some of what she was talking about. And she was specifically saying that her ownership pattern was different than her sister's ownership pattern, that she had additional parcels that her sister didn't have when the probate was completed. Again, because the judge is going to follow what is written in the April law, because there was no will. What I found out in asking this woman is that she was older than her sister. And I said, well, as the oldest child, you actually got the small fractional ownership interests, and your sister and your brother didn't get any of that stuff. And that kind of left it at her discretion on if she wanted to share. That's exactly what had happened. I'm assuming, I assumed that they already knew that she had more than they did, but this explained to her how that happened. Without a will, it kind of follows a slightly different pattern. Again, the single eligible heir rule applies, and you can see how that has changed some of the descendancy patterns for inheritance. Without a valid will, it doesn't matter, because Indian money account funds are not divisible under greater or less than 5%. Those monies are yours. And so this is another chart that helps you see what would happen in your specific situation and who is going to get your Indian money if you do not write a will. I'd mentioned that there are a few items that came up during my research. There is the Navajo Rules of Probate Procedure. You can see the link at the bottom of the slide that goes into the Navajo Nation rules and laws. Two key things that I wanted to point out. This community property, this is fairly common in a number of states. And this is basically saying that on the death of the husband or wife, 1/2 of this community property goes to the survivor and is not subject to probate. Again, this is for non-trust assets. And that the rule number 6 spells out, similar to what we just covered with APRA, who are the persons who are entitled to distribution of the estate without a will. So again, tribes have started to follow some of the aspects of the American Indian Probate Reform Act. APRA provides for a greater uniform law, but our tribal communities are different. And so we strongly recommend that tribes take the time to determine whether or not probate code for trust assets in your nation are going to make sense. Again, I'm not an expert, but in looking through some of the research, I was able to find that grazing permits started for the most part under the Taylor Grazing Act. Again, 1934 is a big year for a lot of Indian issues. Grazing regulations in 37, first grazing permit in 41, and with the grazing regulations in 1956 and Title III of the Navajo Nation Code, the statutes for the Navajo Nation in 1966, it set up the structure that you're used to. It set up the structure that your parents and grandparents originally started working with. Perhaps yourself, you got your first grazing permit under these laws. But from 1966 until today, we're talking a period much greater than 50 years. Nothing has changed in regard to the grazing permits at the Navajo Nation. Again, I wanted to provide you strict or direct information. Title III, the Agriculture and Livestock Code, was passed in 1966, and it addresses grazing permits in subchapter 3, providing for descent and distribution. Again, I don't want to read this to you. You can read as well as I, but it lays out specifically the process that's going to be used for the decedent's ownership of all of their livestock, the permit itself and license portion of that permit, and it will subject all of your descendants to this, whether it be your spouse or your kids. And I did put in here, again, what all of these are. In New Mexico, Grazing District 7 has a couple of caveats that you can read in greater detail. In talking with a couple of different people, they did mention to me that under the permit system, inheritance is what's going to dictate what happens. It is possible through gift or sale for you to make those changes perhaps before you pass away. But again, through the inheritance, you're pretty much looking at either writing a will or hoping against all odds that your family is going to work together to follow through on what you may have wanted to happen. Because if they cannot come to an agreement, I understood and read through the descent and distribution that, again, a Navajo court is going to determine what happens to that grazing permit. So it's critical. It's highly important for your trust assets, for your tribal assets, as well as all of everything that you own, to write a will. It is fairly straightforward to find resources to get a will drafted. For agricultural uses, for the next period of time, it may be possible that the Indian Land Tenure Foundation has the financial resources. We get different grants and we provide different funding streams to legal providers to reach into Indian country. And as such, I currently have limited funds to provide for legal services. So I cannot guarantee by the time you're reading this that that will still be in place. But it is something that you should realize that you don't always have to carry full freight to get an attorney to help you with this process. As I get closer to wrapping up, I'd mentioned that that it is your legal right to change the will as often as you like, but there are specific reasons why you should change your will. If you've been recently married or divorced, and it's may not be common in your area, it's a little bit more common here in the plains and in the woodlands areas in the upper Midwest, that we kind of refer to them as Indian divorces, situation where, you know, she grows tired of him or he grows tired of her and then takes off. And this, for all intents and purposes, people consider that a divorce, but under the court system, the federal, state, or tribal, that's not a legal divorce. So if you think you've been divorced, you may need to get that legal to take care of, and you will want to change your will. One of the horror stories occurred just north of here in a tribal community, a Chippewa tribal community. A young lady was asking questions because her father actually passed away pretty darn near June of 2006. And at that time, the woman, not her mother, but the woman he had been married to, had been gone for 20 plus years, was living down in like Tennessee or Kentucky. And upon his death, well, she showed back up. She was able to access tribal burial benefits because she was legal his wife. She was able to get access to other resources that the tribe provided to this man's family. And she just came to get the money. I mean, so unfortunately, divorce is not always a pretty thing. So as we come back to the wills, if you should get divorced, you will want to make sure that your will gets changed to reflect those differences in your situation. If you have property added through probate, if you buy property, if you've got more children added to your family, or perhaps even your grandchildren, you want to bypass and go straight to them. Anytime those things change in your family situation, your personal life, you should take a closer look at your will, assuming that we've been convincing in why you should have a will, but to make those changes so that they continue to reflect what you want to see happen to your stuff. Again, we work pretty hard to collect and acquire the things. Certain other pieces coming through our own inheritance have strong value to us, and we want to make sure that they end up in the hands of people that we want to continue that legacy of our family. When we look at ways to perhaps not deal with death or to bypass the probate process, especially for trust assets, it is possible to use a gift deed to transfer your legal interests. One of the advantages to a gift deed is that you can continue to use it, benefit from it, perhaps get income from that property by maintaining a life estate, and give it to, again, your kid or your grandkid, or maybe several of your family members. But again, as long as you're alive, if you name yourself as the life estate holder, you can use it as though you still owned the land. But once you pass away, it will automatically extinguish or cancel your interest, your life estate, and give it to the owners that you decided to pass it on to. As opposed to a will, which can be changed as often as you like, gift deed, once it has been completed, is final. Specifically, what I'm trying to say is that if I give something to my daughter, it's no longer mine. I can still use it as a life estate holder, but it's hers the day that the Department of Interior registers that gift deed and transfers ownership to her. And we want to be very conscientious of that. I have some of my own relatives. I'm sure others of us have had people who've fallen prey to either drugs or alcohol. And should we have given that to, say, my granddaughter, and she falls prey to the needle or to opioids, it's hers because I've made that choice. And so again, I want to highlight that it's important to understand that gift deeds are not changeable. The legal term that I have on the slide is not revocable. My name is Jim. I've been with the foundation about 7 years. I love what we do. I'm looking forward to kind of phasing away from some of these online presentations. I think that it has opened our eyes to the ways that we can reach more community members. But for me, the exciting part is to get into tribal communities, deliver these presentations and visit with you, learn from you, also to answer specific questions. And that's one of the downsides to this kind of a presentation, is that it's more difficult to reach me. So I want to highlight that if you were to reach out to the Indian Land Tenure Foundation or send an email to us, you should be able to track me down, and I could see what we can do to either find resources for you, suggest alternative resources that might be able to help you, or sometimes even give direct answers. Through presentations like this, I meet pretty great individuals, and it was actually a presentation I delivered on a similar issue in Tulsa, Oklahoma, that introduced me to one of your colleagues here, and she invited me to share some of that information and to also address some of the issues that are important to you as Navajo citizens. I appreciate your time this evening, this afternoon, depending on when you're taking a look at the presentation. And I look forward to perhaps seeing you out once we're able to travel once again. So thank you very much.
I would like to invite you all to join next Tuesday afternoon at 2 p.m. for the Navajo Farm and Garden Incentive Program webinar presented by Navajo Nation Department of Agriculture. The webinar link is provided there on the screen. If you would like a flyer, leave your email in the chat box and we'll get it sent to you. That concludes our presentation. Thank you, Jim, again for that presentation. I have questions brewing, but I will send it to you as they come, and I look forward to working with you guys.
You're welcome. I appreciated this opportunity very much. I look forward to working with you guys again.
The Native American Producers Success Project, or NAPS project in short, is a collaborative effort between Dene Inc., a nonprofit organization, the New Mexico Cooperative Extension Services, and Dene College Land Grant Office. This project is being funded by USDA's Office of Partnership and Public Engagement and the Outreach and Assistance for Socially Disadvantaged and Veteran Farmers and Ranchers program. The NAPS project field staff consists of myself, our assistant field coordinator, Sharon Sandman, and our technology media coordinator, Jenna Johnson. Okay, next slide. The overall goal of the NAPS project is to increase the profitability and long-term sustainability of Navajo farmers and ranchers. To help us achieve this goal, there are some activities that we are currently providing in 4 key areas, which include improving Navajo farm and ranch operations through a series of workshops, focusing on crop-related topics and livestock-related topics. We are also increasing our Navajo farmers and ranchers' knowledge of and access to available programs and technical assistance provided by USDA, BIA, Navajo Nation, New Mexico Cooperative Extension Services, Diné College, Land Grant Office, and other professionals. We are also strengthening the organizational capacity of the Navajo Farmer and Rancher Congress to address the current and future needs of Navajo farmers and ranchers. So if you are interested in being part of our Congress, please contact us. And last but not least, facilitating Navajo farmers and ranchers' use of USDA programs such as NRCS, FSA, and RMA programs. So next slide, please. I'm going to turn the floor over to Jim Wabindato of the Indian Land Tenure Foundation. And while we're making the transition, Sharon will introduce Jim. Thank you.